Hello, everybody. Welcome back to our third session of today at the Conference of Betweenity on Africa Competition Regulation. It is great to have you back. Today, we are going to discuss a very important issue regarding the quick operationalization of African competition authorities, especially between the period of promulgation and then the opening of the doors. And in order to help us to discuss those matters, we have an excellent panel with us today. And they consist of Adalberto Cauaia. He's the head of the Legal and Litigation Department of the Angola Competition Regulatory Authority. Mr. Hussein Musiho, he's the principal officer at the Ugandan Trade Ministry. We have Mr. Leonard Ugbajah. He's a competition law consultant and a board member of the ECOWAS Regulatory Regional Competition Authority. Ms. Lilian Mukoronia, she's the former Registrar of the EAC Competition Authority. And then Dr. Simeon Kofi, he is the Executive Director of the ECOWAS Regional Competition Authority. With a couple of exceptions, many competition authorities in Africa has taken quite a long time to open their doors pursuant to the promulgation of the particular law in terms of which they were established. And the dilemma with that is that waiting too long before you open your doors could actually afford cartels valuable additional time to exploit markets. Now, according to our records, 7 African competition authorities are currently in the process of becoming operationalized. So they have approved their competition acts, but the authority is not yet operational. An additional 12 national countries are in the process of drafting a competition bill. So that basically means that more than a third of African regulators must still go through the whole operationalization process. And just out of interest, it is quite impressive to note that only 2 African competition authorities have not yet commenced with the process of drafting a competition bill. That says a lot about the speed and the extent of competition law adoption across the African continent. And that brings us to the question: how can newly established competition authorities expedite operationalization? In other words, how can the period between promulgation and the opening of the doors be reduced and optimized? One solution may be to expedite the purely linear jurisdiction-specific processes towards the operationalization, but maybe another solution is to draw on the intelligence and the resources of the broader ecosystem in the interest of speed. For example, a newly established authority could potentially use an intellectual asset base, for example, forms or policies or guidelines, specifically designed, let's say, by a regional authority for the use by new national competition authorities during these very, very early stages of operationalization, or secondments from other authorities could be arranged as part of the process while the authority is still appointing its own staff. So, in other words, not necessarily afterwards as part of a capacity building exercise, but even before the opening of the doors in order to expedite the very operationalization. So today we are going to discuss some of these options that we have towards quick operationalization. And I'm going to start with Leonard, because Leonard has been involved in the drafting of competition laws across Africa, and he's very well acquainted with the different legal regimes, and he is a board member on the council of the ECOWAS Regional Competition Authority. So there's a very good understanding of regional dynamics and national dynamics. Leonard, if you can start with giving us some kind of an idea about the challenges, how they differ between the national jurisdictions and the regional authorities in terms of quick operationalization. Thank you.
Okay. Thank you, Odie, for having me on the panel and for your question, which is a very important one. So I think I'll look at it in 2 ways when it comes to the challenges that new competition authorities face. Number one, it's at the political level. Then number 2 is at the operational level. At the political level, probably the most important resource a new competition authority needs is political support. And but that is not always the case, especially in jurisdictions across Africa that have tracked or contributed to formulating their legal framework. The first challenge is that competition law in Africa is still novel. It may seem popular among those of us who are experts and professionals in the field, but it is not so with the politicians. And because it is not a major plank of public policy in most African countries, politicians don't prioritize competition law as a matter of public policy or as a matter of resource allocation. And that's to be benign, because in most cases, politicians are actually recruited by vested interests to actively fight against the operationalization of the competition authority, even after you fought and won the battle of establishing the legal framework. Now, if you sort out the the issue of political support, which is usually very difficult to address, but assuming you get that political support to establish your competition authority, then you then have to look for ways to navigate the issues of capacity, of funding. Political support doesn't always mean funding, because you could get the political support, but the resources are not just there, or you need to wait for another budget cycle to get the resources, your take-off grant, and all that. Now, you need the resources. How do you mobilize resources for offices, for recruitment? And then when you get that, how do you get the right kind of expertise, which is also a shortage across Africa? How do you get the right kind of expertise to man the new competition authority? Now, when you look at these issues, you realize that what I was saying, most of the comments you've already made addresses most of these issues. So, for example, on the issue of capacity, there's always a bias towards local expertise. Now, this is a national authority, and in the case of national authorities, the law, even if it is not in the law, there is a convention that you have to appoint the head of the agency and recruit staff locally. There's little room to say, oh, let's shop for experts from other parts of the world, even from our neighboring countries, whether on secondment, on contracts and all that. And I think it's something we need to explore more. I remember someone like Tula moving from Zambia to Botswana, and that kind of thing. That's very rare in Africa. But you find those kind of things in the Western world, where they go for the best experts, either on secondment, on direct recruitment. But in most cases, we don't do that. So staffing the kind of money to do the kind of work they need to do is always a challenge. Now, between national and regional competition authorities, the dynamics are not different. For regional competition authorities, it also then goes to the issue of the political will. I'll give you an example with the ECOWAS. The foundational acts of the ECOWAS Regional Competition Authority were adopted in 2008. The ECA as a body was not established until 2018-19. And up to today, ECA is still in the process of resourcing in terms of staff recruitment and all that. So you see how far it has gone. Now, what are the challenges? Yeah, you see prioritization at the level of the commission, but you then have to look at the issue of resources. Do we have the money to fund this? If you look at many competition authorities in Africa today, they rely heavily on technical assistance from development partners to be able to do the basic things like training, like market studies, even investigation, developing their rules and regulations and guidelines and all that. So, but I think if we want to solve the problem, starting from political support will be the proper place to go, because once you sort out the issue of political support, then the other challenges are relatively easier to address. Thank you.
Thanks very much, Leonard. And I must say, Having followed the developments, especially in Egypt, it was profound to see what is the level of political support and how much that meant for the momentum of that competition authority, and also the creation of a prime ministerial committee directly under the prime minister in order to make sure that all the different departments in Egypt are on the same page from a competition perspective. So that's a very important point that you raise. Thank you, Leonard. Ms. Lilian, if I can bring you in somewhere at an early stage. The EACCA has been functional for quite a number of years, but at the time that you finished your tenure there, it has not yet commenced a merger regime. And I was just interested to hear from you, your side. What were the challenges and the blockages that you experienced there across the board, whether it's financial or institutional or political? It would be fantastic to hear what your thoughts are.
Thank you, Odie, and let me say thank you very much also for inviting me in this forum and to participate in this conference. Yes. I really appreciate that. Let me start by saying I can actually identify with Leonard with some of the factors that is talked about, or the challenges that is talked about. Because like you say, in regard to the EAC Competition Authority, really the barriers or the challenges rotate around structural, political, and resources. And basically, let me say the very first challenge that I really experienced when I joined the EAC Competition Authority in 2017.
Yes.
2016. The very first one was the law that was in place, the EAC Competition Act that was enacted in 2006. Unfortunately, it had various and very glaring gaps. And looking at these legal and policy frameworks that are quite weak, actually, when the law is very weak, even the policy organs or the political leaders that are supposed to be really making sure that, this law works, do not see the urgency of establishing an institution because they even do not understand the law of this. Going back, I was looking at our treaty, the East African Community Treaty. Yes, and Article 75, it talks about the element or the principle of competition. But basically, unlike the Commercial Treaty that clearly elaborates under Article 55 on what is required, even as you come up with this institution or as you come up with the regulations, as for the EAC Treaty, just mentioned the principle of competition. But until you come now to the protocols, the Customs Union Protocol and the Common Market Protocol, that is where you find now competition, policy, and law elaborated very well. Yeah. But when you look at the community or the partner states, they are so much into what the treaty says. And if the treaty itself is not clear, then it becomes very, very, very challenging. So basically now, when I joined, and what became challenging is looking at the law that was enacted in 2006. You realize that even the council had the powers to analyze a manja, especially if a manja had the public interest and there was an appeal. You can imagine now you're doing it as a technical person, and then also the council is adding some part of that manja. It was very challenging, so we needed to amend the law to remove the political element, at least from the law, because it means that now will not have any credibility when doing the work. The political people only meet when necessary. They don't meet often. And how do they do the analysis? Then the other challenge that was there is that the law did not give the authority the legal personality. No corporate identity. We were not independent. Mostly, if we want to sign any legal document or if we want to do anything, we want to go through the Secretary General. So it was a big challenge because you are dependent on the the main EAC body, and you cannot really act on your own. And that became a very big challenge. And when you went to the section on mergers, the mergers, okay, the lawyers will tell me that there is no bad law because the law is in place. And we felt that we could actually do something. But looking at the community law, the mergers, even there were no thresholds, no fees, I mean, it was really convoluted. I mean, it was quite challenging. With no thresholds and yet this is a community law. How do you work? It means even a small business and a big business, they were all being captured by the law. So it became quite challenging.
Yeah.
And we felt it was very important for us to amend that law before we can actually start doing the merger cases. We were able to come up with a strategic plan which prioritized the merger regime. But looking at the challenges that were there in the law, then it became very difficult for us to commence that regime. Then the other challenge that we found was the partner states' interest, or the member states. In EAC, we call them partner states. Their interests were quite big. Even when we started the amendments, you could see the fear from the partner states that, oh, now if this merger goes to the community, what happens to us? And there's that element that it's like we are going to lose business, we are the people supposed to be handling this merger. But that was not the case, because basically for us, we were to capture mergers that were affecting two or more partner states. But there was that fear, the interest, and this caused a lot of delay when it came to the amendments of the law. And I think we were able to go through the Legislative Assembly for approval twice. After they approved, a partner state brought issues, and then we had to go back again and start the process with the Legislative Assembly. So I guess it's out of this partner states' interest, because they also have their priorities and they have the competing needs from every partner state. So maybe why would they prioritize the competition law that they even do not understand? Yeah. So that's another challenge that I can say I really experienced during my time. Yeah. The other one is what Leonard has talked about, is inadequate funding. For the Competition Authority, actually, when I joined, there was enough funds to do the recruitment of the staff. Unfortunately, this was just as per the money that was allocated to the authority. But looking basically at the entire community, there were not enough funds to do so many other activities and other programs. And what happened is that the council or the policy organ decided now there will be a moratorium. And I was just starting now to really operationalize and do quite a number of activities, and with the priority of recruiting staff. And the moratorium was that we could not recruit because there were no funds. And even when I started, I tried to say that we end the funds, you are still part of the community. And like I've said, we did not have the legal mandate. So we were depending on the entire EAC as a community. So it was not possible because of this moratorium. So funding that was affecting the community actually translated also to affect the authority. We could not go beyond what the moratorium was indicating in regard to recruitment. And that is why until today we have challenges, because I know funding is really an issue. Yeah. Then the other one that I really tried to do, and I really wanted it to work, I thought I could have some secondments, especially from the partner states that had mature competition agencies. And in this case, at that time, we had Tanzania and we had Kenya that had operational institutions, and they were doing cases. And we thought maybe we could get some staff and get seconded to the EAC. Unfortunately, again, like I said, we did not have the independence. We were told there is no secondment policy. EAC, by then, though I think right now they have done one, they did not have a secondment policy. So they could not second people from the other authorities, not just our partner states, even from outside East Africa. So it became quite challenging, because now I could not get extra staff even to help me really lay the infrastructure or do the operationalization that was required. And the other one was what Leonard talked about the limited technical capacity. I recall when EAC first advertised to operationalize the authority, they wanted about 6 staff. Unfortunately, the requirements were quite demanding, because they said they wanted someone with 15 years experience. and they were biased towards getting the staff from the East African community, not beyond.
Yeah.
So they looked around and they could not get someone with 15 years of experience in the East African Legion at that time in 2016. So I'm telling you, that's how I ended up being the only staff who was recruited then. And so now, as we are waiting to do the others and amend even the policies and amend the law so that we can be able to recruit the staff, we were caught off. And I remember when the moratorium came, I really had to appeal. And that is why the council was able to revise the years, at least to come to 8. And when they said 8, I was able to get a few other staff. So it was also very challenging because the years of experience, we do not have that expertise in the region, and it becomes very challenging. But I can say right now, I am very happy to say we've done quite a lot of amendments. And even inside the law, we've captured the issues of the kind of staff we want, what qualifications, what kind of experience do we want. And now it's very, very friendly. And the law was actually passed just before I left. Because I left end of November, 30th of November. The law with amendments was actually passed. And now the EAC Competition Authority is a corporate, as the corporate identity, it has the legal personality, the thresholds are there. I mean, the recruitment issues have been sorted. So I'm hoping now they'll be able to pick up. But those are some of the challenges, really some. Not all that I experienced. Yes, thank you.
Ms. Lilian, I have new respect for you. It must have been very challenging trying to be effective in the midst of all of those constraints. And thank you for what you have done for getting the law and the policies to where they are. We really thank you for that. If I can turn to Musiho. Musiho is officer in the ministry in Uganda. Can you give us some indication of the blockages that you faced as part of the whole process of getting to the point of operationalizing let's call it the unit within the ministry, Musiho?
I'm happy to join my colleagues and those who are listening to us discussing quite a very interesting discussion. Competition is very interesting and very unique. I want to say that I'm happy to have been part of the team that has seen the development of the competition law in Uganda, right from the time when we started developing the competition policy. I also want to note that I think we have taken the longest time in the region, I think, trying to develop competition and consumer protection law. The process of developing competition law in Uganda started quite some time back. That was around 2012, only to be ascended to in February 2020. So that is quite a longer period that we have taken developing this law. But of course, that has not gone without challenges, and I think the process of delay has been a result, has seen so many challenges for us to come up with the law. We have taken baby steps towards building an institutional framework to implement competition and consumer protection. But the question is that we are faced with. Unlike other jurisdictions in the region, Uganda has taken a different approach, which can also pose a challenge on how we can implement the competition law. When you look at our law, because Uganda has been going through what we call a nationalization process, so we have excluded anything to do with an authority. So we are going to implement this law through a ministry. But what is very important, the law gives a blanket provision on whether it should be a unit or it should be a department. So it is now upon the technical people to advise whether what can deliver the mandate to implement competition law. What has been some of the challenges? One, we have not had an institutional framework to implement competition at first. Much as we had a policy that was passed in 2014, we could not go on to implement the law because of the lack of, one, the laws themselves, but also lacking the institutional framework. It has been a big challenge. We have just submitted the institutional framework to public service. These are just our proposals, and what we have proposed as a country is that we may need a department to implement competition, and this came as a result that we benchmarked with Kenya, our neighbors, because they also started as a department in the Ministry of Finance, and we hoped maybe we can justify later that we need a separate institution to implement competition and consumer protection. Now, what are the trust issues? Of course, this has also been a challenge. We also have institutions in Uganda that implement some aspects of competition, like the Uganda Communications Commission, we have Bank of Uganda, we have the Insurance Regulatory Authority. These have some components of competition. It brings the issue of collaboration. There has been fear that when we start implementing the law, then some of these institutions may cease to implement some of these provisions on competition, especially on mergers. But I think it has been quite a tall order for us to try and create sensitization to show that as much as we are coming to implement the law, but we can still collaborate with these institutions for us to implement competition, and everybody will achieve the intended objective. Much as they may look at the technical issues, but we may also have to look at the trade issues. What are some of the trade issues that may be posed in the market as they look at some of the technical issues? So that has also been a challenge, that the fear of losing mandate to one institution or not. When it comes the procedures, it has been a challenge that yes, we have the law, but for us to implement the law, we also need the regulations, because we thought when we have the law, we can easily implement competition matters, but we also realized that some of the aspects need regulations. They are not implementable without regulations. And we also realizing that even when we have regulations, we still need other tools for us to be in a position to implement this law. So you see that there is quite a number of issues that are required for these younger institutions like Uganda for us to take the first step to try and address any of the competition matters in Uganda. And now that institutions know that we have the law, they have not stopped from notifying. Still, institutions are notified to say, yes, we have this merger, we want your advice on how best we can do it. But now, of course, we can't, we have advised, if, for example, a matter has cross-border effect, maybe now we advise the institutions to notify either EAC or notify COMESA, basically. Just because we cannot handle some of these matters, because we have no law, we have no regulation, actually no regulation. This morning, I'm happy that as a result of the efforts that we have been engaging with some of the sector regulators, there is a merger in the insurance sector, and what the Insurance Regulatory Authority has done is to also inform the emerging parties to notify the ministry.
That's good.
But that has been as a result of our engagement, collaboration, and trying to build synergies that as we implement some of these matters, all of us need each other, because they have the technical know-how in that area, and now we are the authority to implement the law.
Yes.
Now, what does this comes with also a challenge. We have not, at the moment, as we develop the competition regulations, we need to harmonize the issues of double notification. For example, if a merger is happening in the private sector, where do these people notify? And where do they pay the notification fee? Those are some of the matters that we are still discussing. And maybe as we go along, we may have to go into an understanding with some of these institutions to have frameworks on how we can facilitate the implementation of this law. The other aspect that we have seen, which I think also poses a challenge, Uganda has benefited so much from the capacity building program that has been happening across the region by EAC, by COMESA, and you see what others have done and what others are doing. That also brings a fear on whether you can start or not, and where do you start from. There is that bias. You want to look like others. They have done a lot, but for you are still making steps. That also creates the fear of starting.
Yes.
I think it has been a challenge.
Yeah.
But also the systems, building systems to try and implement the law. These are systems that are not in place. Some of these systems need a lot of resources to put in place. Systems that can easily be used to notify, complain, because it's not that people every time will come with papers to notify or to complain or to lodge a complaint. We need systems, which systems are not in place at the moment.
Yeah.
But of course, the beauty about that, there is willingness for us to go into the right direction. Out of the EAC partner states, I think we are lagging behind, but we have identified some of our challenges, and we are trying to partner with the private sector, civil society organizations, and we have positive results. Some of them are promising that they can work with us to build some of these systems. The other aspect, of course, people, when the law is new, people are not aware about the scope of the law. But we've been working with the private sector, especially the Uganda Manufacturers Association, because they have the capacity to mobilize their members, and we have been engaging, and for us, we have been passing on the message. What is the intention? If we have this law, how will the consumers, how will the businesses benefit from the implementation of competition and consumer protection? So those are some of a few challenges that we have, and we call upon everybody that with a lot of capacity built in the region, I think we are glad that we have been learning, and we call everyone to come in and give us the necessary tools for us to be in a position to implement this law. That is what I can say, having been part of this process in building an institutional framework in Uganda. I submit. I thank you everyone for listening.
Thank you very much, Musiho. It's been a great challenge. Thank you for being part of that. If I can quickly go to Adalberto, I noted from where I was sitting over the past 4 or 5 years that the Angola Competition Authority was very quickly out of the blocks. And I'm not sure whether it's a Portuguese thing, but Mozambique also moved fast. And I was wondering if you could give us some of the reasons why that happened so perceivably seamlessly. If you can help us with that, Adalberto.
Thanks, Odie. Thanks, dear colleague. It's a pleasure to be here to talk about competition. You know, guys, here in Angola, there is no other people talking about competition. We just start the movie. And when we would like to talk to someone, we can go, we need to go out of the country because it's very, very new things here. So in Angola process, I think here in authority, we think that it's not was as quickly as the necessity of the country and the economy. So there is a big gap between the established law and the authority and the policy because we have a historic background with state intervention on the economy. So the mind of the people and the politician, even from the people who work to private company, it's not comply with competition policy. So there is instead thing because we had in our strategic long plan since 2008 the intention to create Angola Authority and to competition law. And also after 2 years in our constitution, we put the competition and the free market as a way to organize the economy. But only after 10 years, we approved the legal framework. So it's not so quick as we need it. But after that time, the context changed. So in 2007, we changed the presidents of Angola. After general elections and with all economic crisis in the world, also in Angola, the price of oil and gas down, the people think that is a good way to approve the competition law. This was in May of 2008 from National Assembly. Then after maybe 5 months, we had a presidential decree who defined the threshold for mergers, acquisitions, and dominance and other inferior norms. After that, in December, there was approved the decree who established the authority, and then after 1 month, the board was nominated, and then they opened the doors after that. So we did it without any technical assistance, without anyone who has tried to implement these new laws. So what we did, we use intellectual property asset from ICN and ICF, NC, CC, SA, and we work quite a lot by ourselves in a house to study all those documents and to operationalize the laws. So what our first decision was about assessment to a presidential decree who established and obligates all public institutions to work with a public company to a public press company to put those stationery and merchandise things. So in that moment, we depend to the Minister of Finance, and we had at that time a good ministry who accept and allow us to do as the law says, and we did this recommendation after 3 months that we opened the door. We didn't have the form to notify the mergers acquisitions. We use it because our law it's very similar of Portuguese law, and our legal system it's like a we use also these documents to adapt and to use for us. But in that time, for example, to receive mergers and acquisitions notice, we used to receive the documents and the requisitions of the companies, and then we sent a checklist to put another information. So the board was appointed at January of 2019, and then in July we had our first decision in mergers acquisitions. On that time, we also received the first notice about price fixing that only after 5 years, maybe, it was in 2023, we have our first decision in about price fixing. So to go forward, I think there is some conditions. The political framework was very, very important because every people was thinking about to change Angolan economy and the way to do business. And it's not only for competition area, but also for privatization, to reform the rules, to open companies, to remove barriers. There is a lot of movements that are in the political programs to receive foreign investment and to have a good environmental for business. So in this context, Angola also operationalized the competition law, because only in December of this year we had the opportunity to go to the Portugal. We stayed there for a week, the boards and the directors of the areas, to know how the people works and organize the things. This gave us another perspective from inside of one competition authority, but it was about almost 1 year. We already took decisions. We already make some steps going forward, but only in about also 1 year since January we start to publish our regulation that is the competence of authority. We approved the form, the mergers acquisition form. We approved the guidelines. We approved a lot of instruments that allow us to have a designed process and the how to do the things from competition authority perspective. Just about 1 year, and then we had COVID-19 time, so we stay quite took us a energy that we started, and we said a little time to how to manage this, but after that time we continue to do our things. One of the reasons that we are thinking is that we built the authority with previous conditions. For example, there is stability of the board. The nominees for the board are the same since the authority was created. The authority have a conditions to recruit a good staff because took people from university, from law firms. For example, me, I used to be a lawyer in a private firm. They hire me to be here, but it's because the Minister of Finance, then other public servants have a good conditions to work. I'm referring about infrastructure and technology instruments, but also they have a good salaries. They have some conditions that permit the authority to recruit a good people. We are few. The staff is very few. In that time, it was about 25, almost 30, but we made this work. That's just because we had the opportunity to hire a good, experimented professionals who quickly read and make investigation and understand about competition. Because remember, Angola was to be a socialist state and with a lot of intervention in the economy. Even our curriculums at university, I mean economics and law universities, we don't learn nothing about competition or even free markets. So we had to read a lot, to discuss a lot, to use the material on the internet. And after some time, we make some post-graduation in Portuguese universities by Zoom, like we are talking now. And this allow us to have understanding about the competition laws, about investigation. And we still feel that we have very big challenges to improve our work. So ever stability with the boards and also the heads of the areas, mergers, anti-cartel, even me in legal, was very, very appropriated to go quickly and to have some development, because we started and we go forward together. I think these conditions, the political framework and the resources that we had allow us to 1 year after operate the Angolan Competition Authority.
Thank you very much, Adalberto. And one can hear there's a political system that is enabling, but there was also a lot of energy and initiative, and looking on the internet and finding guidance from other established authorities or institutions or multilateral organizations. That is quite impressive. Leonard, if I can get back to you, and if we listen to some of the challenges of what Ms. Lilian indicated and Musiho as well, to which extent could one draw on the broader system to help, for example, the Ugandan ministry to expedite, let's say, effective operationalization? If you could think of some ways, for example, are there ways in which COMESA could assist, or anything else? I'm just interested in your views.
Okay, thank you, Odie. Yeah, you mentioned correctly if COMESA could assist. So the good thing about the Eastern African flank, and to an extent, well, the Southern and Eastern African flank, is that they have relatively strong national and regional, and then COMESA as a regional competition authority. For a new agency like Uganda, which I have followed, or a new regime, because they're not really an agency as such, they have the benefit of good neighbors that they could borrow from, not just in terms of designing their system. Of course, I'm a champion of convergence in design. So it means I will support them borrowing both institutional design, substantive provisions, borrowing from what their neighbors have in the law. But beyond that, I want to see them also establishing strategic relationship with, say, Kenya, Tanzania, and then COMESA as the regional competition authority. And what will be the content of that relationship? I would like to see them do staff exchange, so they could request for secondment from the CAK, the Competition Authority of Kenya, short secondments, because almost all competition authorities in Africa are resource constrained in terms of expertise. So you may not be able to take someone away for too long. So do short exchanges, 1 month, 3 months, and that get secondment from Kenya, get from COMESA, and then also send their own staff to those other agencies. So some kind of exchange, to do that. Now, what that would help them to do, it will help them to understand the law they are supposed to be implementing and to learn from the experiences of other jurisdictions that have gone ahead of them. So definitely, yes, secondment is a very important element. Now, beyond the secondment, capacity building, support like training. I'm aware Commercial is doing a lot of that across that region. Now they can develop a structured training that doesn't just focus on the number of staff they've recruited within the ministry, but that should integrate backwardly to the learning institutions in the country. So, for example, it's time to start thinking of developing competition law and competition economics focused academic programs. They could be short courses, they could be diplomas or full-fledged degree programs. In the law schools, in the economic departments, maybe in the business departments in some of the universities. Now, what that does is that you're building a groundswell of expertise, that you're not only using as an institution, but those could also serve the interest of your stakeholders, the businesses that are going to be making reports or making complaints or be investigated, maybe the courts that are going to sit on appeal over your judgment. So the idea is to create a groundswell of competition law aware and knowledgeable community of practice, if you call it that way. And to do it, that means you need to extend your capacity building beyond the institution. Another critical element that you need to carry along in your capacity building effort is the civil society. For me, in most of the countries I have worked in, I've always targeted the law societies or the bar, if you like that. You need to get them along. And what that does for you is not just that you're making them aware, but you're also building, in a way, you're also building political support. When Nigeria was in the process of adopting a competition law, which really dragged for about 19 years or so, the Nigerian Bar Association was instrumental in keeping the conversation going, because in most of the annual meetings, there were just side events, focused on competition, and so that kept the competition going. That kept the conversation going. So for new authorities, I would say, you need strategic advocacy to win political support and funding. Strategic advocacy. You need to find champions within the political and the policy organs of government that would understand and champion your cause. When that political support, then you need to look for creative ways of mobilizing resources. So explore available development assistance projects. That's usually like the easiest, because you can't go to private sector to look for funding also. And government resources are almost always constrained. So look for strategic funding sources, then rely or seek strategic partnerships with the existing or mature competition authorities within your neighborhood or even elsewhere. You can go as far as Europe if you have the relationship with the EC. So they'll be happy to offer you assistance, either occasional training or even secondment, for a period of to be able to ramp up your capacity. So strategic advocacy for political support, dynamic sources of funding, then dynamic sources of expertise, which could be secondment, training, and then finally building a groundswell of a community of practice. That could be like developing a competition culture among your critical stakeholders, the businesses, the academic institutions, the civil society. Those will also be the voices that will speak up for you when you face political pressure or political backlash, and they would also help you convince the politicians about the importance of the work that you've been tasked to do.
Thanks very much, Leonard. Thank you so much. And if we look at the period between promulgation and operationalization, you having drafted so many African competition bills, do you perhaps see that there are room to include in those bills certain things in relation to quick operationalization, certain measures or ideas, anything that one can actually put in as transitional provisions to...
Yes. Yes, I can't remember if this survived the Nigerian bill. I can't remember. But the time we were fine-tuning the Nigerian bill, I think we had a provision that required the Minister of Trade to constitute the board within 6 months. Now, I can't remember whether this provision survived the legislative process. But what I do remember specifically is that the time frame between the signing of that law to the constitution of the board was more than 6 months.
Yeah.
So yes, there's room in the law to insert provisions to ensure that the board gets constituted, that the commission becomes operational. But you would also realize that such provisions could also defeat the bill itself. So politicians are usually sensitive to provisions in the law that tie the discretion of policymakers. You know, so they will tell you what if we don't have the money to operationalize within 6 months. You know, so they would like a more watered down language that would say as soon as practicable. You know, but once you have legislative, once you have timelines included in the legislation, it could pass in rare cases, but politicians tend to generally push back on such provisions because I mean they perceive it as unnecessarily restricting of political or policy discretion. You know, but yes, it could be used. Such provisions could be used, and also you could also explore provisions that allow the authority to recruit from anywhere in the world. You know, or basically from your region if you don't want to go too far. So you can say, you know, from the East African region, from the West African region, you know, and then there are also provisions I have used in some of the bills I have drafted, and that's provisions that allow the authority to retain consultants on contracts who are not direct staff, you know, of the authority, but they are consultants. They are recruited based on their expertise on contracts, you know, separate from the formal structure, and you can retain them for 6 months, 1 year, 2 years, just you know, helping to support the work of the authority. Because another problem is that you know, like our friend from Angola made an important point about the working condition in the competition authorities.
Oh yes.
If the condition of service is not substantially commensurate to what you have in the private sector, then it becomes difficult for you to attract the kind of talent that you want. You know, so one of the ways you could solve that would be to allow the authority to recruit experts on contract basis, you know, and be able to pay them as much or close to what they would have earned in the private sector. But the best or the most sustainable approach is to I always advocate that competition authorities should have conditions of service that are not necessarily tied to the civil service conditions because of the kind of experts they need to attract, you know. Or otherwise, you have competition authorities that are they have, in terms of number, they have people, but in terms of expertise, it's almost non-existent. Why? Because their remuneration package is not attractive enough. But the competition experts, or even people who have rudimentary knowledge of competition, are in high demand. They are scarce in the whole of Africa, you know. So how then do you want to attract those talents if you're not willing to pay them a reasonable remuneration? Yeah. So those are some of the strategies that could be explored.
Thank you very much, Leonard. Just a quick one. What would you think in relation to transitional provisions, making provision for the use of forms? Let's say of the region. So let's say it's a COMESA member state, and between the time that there's a promulgation and operationalization, that they use the IP of their member state, for example. Would that be feasible, or is that a bit naive?
Oh, you mean like forms for filing?
Yeah.
Yeah. It really, I don't think those like issue of forms really are major constraints in operationalization. But they could be required to, or they could be allowed to use the forms from other jurisdictions to fill their own gap. But if it's about drafting forms, where you have the problem is in drafting the rules, the regulations, or guidelines, which would generally come with the forms, you know.
Yeah.
Now, but if it's just for the forms themselves, you know, that wouldn't be a problem.
Yeah.
But let me share another idea I think is critical to operationalization, to quick operationalization, which I've also tried to experiment in some of the bills I have drafted, is to allow, and this is not popular in Africa, to allow the right of private enforcement, you know. So not private enforcement in terms of at the level of damages, no. Private enforcement on the first instance. So that means the law is there. If you have a complaint, you take it to the commission or to the authority, but you know, you're also free to file a direct case in court challenging any business that you think is engaged in activities that undermine the competition law. You know, so when you have, of course, it has to be limited because there are certain kind of cases that the courts may not be in a very good position to decide. For example, the courts cannot. So a business could challenge a merger in court to say, you know, though by the provisions of this law, this merger is anti-competitive, although we don't have a competition authority to review it. Yeah, potentially the courts could review it, but the result may be suboptimal, you know, so I acknowledge that. Now, but there are other cases that are easy to challenge in court. So, for example, you can challenge abuse of dominance in court. You can challenge cartel conduct in court, you know. So, if the businesses and lawyers are allowed to challenge those practices in court, then it gives traction, you know, to the application of the law. But what that would also mean is that that could also put pressure on the government to establish the institutional framework, the authority to implement the law. But traction is the goal.
Yeah.
Traction is the goal. I remember I was in a country recently, last year, when I was drafting their bill, and I had a meeting with the Bar Association. They've had an old bill that was never operationalized. An old law adopted, never publicized, never operationalized. It was just there in someone's filing cabinet in the office. And I asked the executive of the law commission, of the bar association, whether they are aware that the country has this, and they were not aware. Incidentally, one of them in the executive there is a trade expert, and he said, "Come, this is my master, you know, and I've been practicing in this country, and I didn't know we have such. Please, could you give me a copy of that law?" And I told them, as lawyers, you know, that you could find the solution to some of the problems your clients are having in this law. And you don't have to wait until the government sets a competition authority. Incidentally, that national legislation allowed for private enforcement.
Can you believe it?
So that's basically one of the laws in Africa, specifically Liberia, actually. Because they are more patterned after the American system. You know, so it was all about private enforcement primarily, with limited scope for administrative enforcement.
Yes.
You know, so I thought you could already go to court with the law the way it is. You don't even need any agency, you know, and they were quite happy to learn that, you know. So private enforcement is one of the ways to accelerate operationalization.
Thanks. Thank you, Leonard. That's a brilliant thought. Thank you for that. Ms. Lilian, based on all of your experiences, are there any ideas on how to on how to get out of the blocks a bit quicker, regardless of the area for example, finance or institutional, any low-hanging fruits that can quickly be achieved from your perspective?
And actually, I think one of the things that I would really propose in order to really quickly be able to operationalize an authority is adopting a phased operationalization strategy. You realize that at times we just find ourselves there, like Uganda said, there is the law, and they have even the fear of moving forward.
Yeah.
But I'm thinking if you can have some interim measures, immediately you get that from, maybe have a transitional task force that is embedded within the ministry that can really assist you come up with a formal authority. I think this will be quite a good idea because this transitional task force can be able to come up with the requisite infrastructures that are required. They have a checklist and they know exactly what is required so that you do not move haphazardly. And I found myself in this situation when I joined the EAC. When you just go, you find the law, you don't know where to start, where to head, it becomes very challenging. But I think really coming up with some interim measures, even if it's within the ministry, to help you have a checklist of what is required can really quicken the operationalization. And then the other one is you talked about having forms, having guidelines and regulations. I'm thinking it's very important when you come up with the law to simultaneously also draft the regulations and the guidelines and the forms that are required. Because one thing I've realized is that there could be a lot of misinterpretations if you take so long to do it.
Yeah.
And one beautiful thing that we did as we were amending the law, even though we were not sure whether the amendments would be accepted or not, we kept on drafting also the regulations. The beauty with the EAC is that the regulations are basically at the end of it all approved by the council. They don't go to the legislative assembly. And then the guidelines are approved by the board. So it becomes a little bit easy, the guidelines and the forms. So we've been able to do all those together simultaneously with the amendments without really delaying to avoid a lot of misinterpretations and clarifications. And then the other thing is that looking at our region, we have the COMESA, like someone has said. We also have some mature agencies. We have Kenya, we have others even like South Africa. We have the EU and so many other international bodies where we can get these templates and we can quickly look at our environment, scan our environment, and see how we can domesticate them because it becomes quite easy other than you starting right from zero.
Exactly.
Just see how to domesticate based on your economy or based on your environment, and it becomes quite easy. And then the other thing I think that can really help us is really we need to lobby. I don't know what good one to use, but we need to lobby, establish champions, either within the partner states or regionally, people you can work with, networks.
Yeah.
One thing that I did is I remember I would request for opportunities to speak in any meeting that I could hear is taking place regionally, especially on trade, or manufacturing conferences, judges conferences, and I'm requesting for opportunities within the region to go and speak so that I can at least say something about competition policy and law and the benefits of enacting the competition law and having a good institution. Also within the community, for example, for my case, I remember when I went to the Legislative Assembly to defend my budget, or even to Accounts Committee, to the Trade Committee, I would always start by telling them what are the benefits of having the competition policy and law. Please, we need to lobby as much. We need to establish champions so that we can be able to send the message on the importance of having this law. Because one thing, like most of my colleagues have said, people are not aware. They do not understand what we are doing. Then where possible, also use case laws. You may not have done a case law like Uganda or even the East African community, but we have cases done in our partner states or even with COMESA that are touching on the East African. What impact? Can you analyze the impact? And then when you are trying to explain the benefits, you can use such cases. The other thing I think is leveraging on the regional bodies and the peer support that you've seen and the mature competition authorities. They have so much to offer.
Yeah.
In terms of training, in terms of consultation, coordinating activities, they have so much to offer. And I remember Uganda talking about double notification. This is what we have been experiencing, and we've been having quite a good discussion with COMESA because we realize 5 out of 8 partner states of the East African community are also members of COMESA. And all these partner states are required to notify the East African community and also notify to the COMESA Competition Commission. And it becomes challenging because, like they have said, our business is to ensure that really there is that ease of doing business. We do not want to become a burden to our business community instead of facilitating them. So we are coming up with cooperation frameworks with partner states, with also the regional bodies, because I want to believe this one will help us to coordinate better and also to consult better in terms of cases. If we realize that this case really falls so much on the East African region, then we can see a way that the East African community can handle without burdening our people. So basically, those are some of the few things I can think of quickly.
Yeah.
We need a lot of public engagement and buy-in. We don't really require to have physical meetings where we need money. I think now with the technology and what you are doing, Odie, is a very good example. You have convened this meeting and we can discuss and talk through technology.
Yeah.
Let's prioritize the digital infrastructure and see how we can be able to reach out, to engage the public, to engage the relevant stakeholders, and got to also get the political buy-in as we really create awareness and sensitize them on the importance of this law, so that at the end of it all, we'll be able to really implement what is required of us.
Yeah.
Thank you.
Thank you. Thanks very much, Ms. Lilian. It sounds like very convincing and very practical ways to make sure that there is an ongoing process of getting buy-in from the broader stakeholder group. Adalberto, just something interesting that I picked up, and I mentioned that the Mozambique Authority was also fairly quick in terms of filling that gap. And there was also a very interesting other incident that happened a couple of years ago. I think it's about 2 years ago. The first selected chairperson of the Mozambique Competition Authority was dismissed due to inaction in relation to a particular complaint, I think, that was filed or that was filed. And I get the impression there's a very strong bias towards implementation at the Portuguese competition authorities. Is that correct? Can you share anything in that regard?
I'm afraid I can't speak to all Portuguese African countries because the reality are quite different from country to country. But from our bilateral relationship with Mozambique, they are also very active. There is interesting thing. It's their law. It's faster than ours. So they approve first the law. I think in 1913, but they only nominate the board after too many years after us.
Correct.
So, and our laws are quite similar also because I think our law it's more similar from Mozambique than Portugal, and the reality are also close, not from Portugal but Angola and Mozambique. And we talk a lot. We have a small informal network with Portuguese country, including Portugal and Brazil, we call Rede Lusófona. So in this network, we used to talk and change experience.
Yeah.
We made meetings whenever we have these all big meetings as UNCTAD, OCDE, or even some conference in Portugal.
Yeah.
We already host one here in Angola beside our annual conference. And also because we are in stage, I think small steps ahead of Mozambique, we change drafts of documents. We make online conversation about too many things.
Yes.
And we think that they are coming very, very quickly. But also they have a constraint with the capacity building with the collaborators and also the financial issues as us. So they are doing their best. It's different the story of Cape Verde that they have benefit from technical assistance from UNCTAD. They have a program with UNCTAD that they help to draw the law and also to operationalize the authority. They make changes right now. There is two people from the board that change the president and another member, but still have we continue talking together. Recently in another forum, we talk with all competition Portuguese authority, and we have this facilitation because the language could be a barrier to talk with other countries, and we
exactly.
are very few countries in Africa that speak Portuguese. So our resource from even studies and material and procedural we use to see first in Portugal and then in Brazil.
Yeah.
We have also the same law family, Roman law, so it's easier to understand how the courts work, how the principles and how we can appeal, decided, and make the process. But about São Tomé and Guinea, they don't have authority right now, until now. But also they are represented in these forums that I talked about. Red Lusófona and then CPLP. It's a Portuguese country's forum that they are also in the business division trying to build a division, a section of competition policy. But I think we have a brief and we are push each other to competition in Portuguese in Africa.
Yes, yes. Thanks. Thank you very much, Adalberto. And Musiho, Musiho, I'm going to ask you, and unfortunately this must be the last question. I can't believe that the time has flown. Is there a benefit to be in the ministry? People are always saying it's much better to be an independent authority, and there's a good rationale for that. But can one also argue that there are certain benefits of being hosted within the ministry?
Yeah, you have already pointed out that we tend to focus on the negatives, that being within a ministry may not come with benefits. But we have also realized that I think it is even better for you to be attached somewhere as a baby to allow you grow. Us being in the ministry does not stop us or does not kill the intention that as Uganda we can have an institution supporting some framework to implement competition. But it's very important for us to build the capacity, and that is the need for us to be in a ministry rather than being an independent institution. here it is very easy to lobby a government because the existing institution, we're using the same existing mechanism to lobby for resources, and also to begin small. As you grow the capacity, you recruit the numbers, which then you can justify to come up with a separate institution. We have seen this happen before, that there are some institutions in Uganda that have started within the ministry, but they have grown and they have justified that they have become separate entities. But also what I can highlight now, whether you are in a ministry or not, what is very important are the decisions that you come up with. Even when you are a separate institution, you can come up with the wrong decision. But it's very important for us to exercise the independence and also do your work as guided by the law.
Yeah.
And make good decisions. Whether you're in a ministry or not, you can still make decisions that can help promote the competition in Uganda, but also facilitate trade. So those are two views, but it will depend on how we operate, whether we still need to remain in the ministry or we justify the case that we think based on some of these decisions, maybe may need to have a separate institution. The other one, which could be the biggest argument, has been the independence and maybe political peddling by government, especially that maybe as a ministry you may not make independent decisions. But what we have done in the law for us to try and remain independent, also make decisions that may be trusted by the public, is to have what we have termed as a technical committee. The committee, the way we have proposed is that to allow membership from other institutions, so that when a decision is made, it is a consensus and it is based on information or data and getting views from other institutions that have also been implementing competition. And we have made a suggestion of the membership on that committee that we can also co-opt somebody who is technical, depending on the matter that you are handling. If you're handling maybe a matter from the financial sector, maybe you could co-opt somebody from the financial sector who may still give technical input before an institution come up with a decision. So those debates are there, but I think we have not lost hope for us to think that we can still implement competition and come up with a justifiable reason as to why we need to be in a ministry for us to deliver.
Yeah, thank you. Thank you, Museo. Thank you very much for those views. Panelists, thank you very much for this very, very insightful discussion, sharing your challenges and some solutions and some positives. It's really much appreciated. And yeah, all the best with your extremely hard work. We often forget how difficult it is, especially when a political environment is not enabling. Then it's really cutting teeth. Thank you for your participation and your insights.